Ever wonder what happens when a defendant walks into court, declares themselves their own attorney, and challenges the very authority of the judge? Get ready for a courtroom clash in Detroit, Michigan.
How he got on my docket, I don't know. It's just the city of Detroit versus Albert Heimer Hicks Jr. Case number SP 1442547, counts 1, 2, and 3. SP 1442761. Appearance for the record, please. And strike, now wait a minute, SP 1500871. Appearance for the record, please.
That one ours?
Yeah.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
You're your own attorney. You're an attorney registered by the state of Michigan.
Licensed to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
This is a classic sovereign citizens tactic where individuals declare themselves sovereign and claim not to be subject to the government laws or court jurisdiction. Mr. Hicks states he's his own attorney, but the judge immediately clarifies that simply being a citizen doesn't grant you a license to practice law in Michigan. While the Sixth Amendment to the U.S. Constitution and Michigan's Constitution, Article 1, Section 13, grant individuals the right to represent themselves pro se in court, they are still bound by the same rules of procedure and evidence as licensed attorneys. They receive no special treatment. His challenge of practicing law over the bench is an attempt to deny the judge's legitimate authority, arguing that the judge is acting as a litigant rather than an impartial arbitrator, a common pseudo-legal argument with no basis in actual law. The judge is clearly trying to establish the legal framework which Mr. Hicks is actively trying to dismantle with these common but legal meritless arguments.
I'm not litigating anything against
you. Okay, you have been practicing law across the bench since we started this, and I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer to send back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're a grown man. Let's have let's
You
have
wanna
a
know
few
something?
seconds. Wait a minute. Let's have a few second conversation, okay? Now
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No. Don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay. So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
Here, the judge firmly reasserts the court's authority and jurisdiction. Jurisdiction, the court's power to hear a case, is established by state constitution and statutes, not by a defendant's personal belief or challenge. The Michigan court rules, for instance, clearly define the jurisdiction of district and circuit courts. The judge correctly states that the Michigan Constitution and court rules establish his jurisdiction, and therefore he is within his legal right to deny Mr. Hicks's motion challenging it. Sovereign citizen arguments regarding jurisdiction are universally rejected in U.S. courts because they misinterpret fundamental legal principles. The judge's command to take your hood off and his refusal to tolerate interruptions are essential for maintaining courtroom decorum and ensuring orderly proceeding, which is part of his inherent judicial power.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
You don't even have a
I
license
thought
to
about that.
law.
Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
This exchange highlights an important legal right, the right to a jury trial. The Sixth Amendment to the U.S. Constitution guarantees criminal defendants the right to an impartial jury. However, the decision to process with a bench trial whether a judge decides both facts and law typically requires the consent of the defendant, the prosecutor, and the court. A judge is not obligated to grant a bench trial if they believe a jury trial is more appropriate, especially in cases where the defendant's conduct might influence a judge more directly. Here, the judge is offering a choice of a jury trial, ensuring Mr. Hicks' constitutional right protected, but denying his assertion that he alone dictates the trial format. The court is trying to move past the pseudo-legal arguments and ensure the case proceeds according to established legal procedures.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course, I do.
All right. All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out, or at least mute yourself.
Our research indicates that Albert Heimer Hicks Jr. has a history of legal challenges, often employing sovereign citizen arguments in various Michigan courts. Regarding the specific case number SP15008721, which appears to be from 2014, reports suggest that Mr. Hicks refused to participate in the trial, leading to a default judgment against him. While precise sentencing details for this exact hearing from 2014 seem to point to a dismissal, his consistent non-cooperation often results in convictions by default or contempt of court charges in other documented cases. Mr. Hicks also has filed civil lawsuit against other court officials, which have often been dismissed for failing to follow proper procedures, such as not paying filing fees. This pattern underscores that despite his persistent challenges to jurisdiction, U.S. courts consistently uphold their authority and apply established legal procedures regardless of a litigant's personal beliefs.